infer that the defendant knew his vehicle could not advance in front of the suspect to block his flight without making contact. And last, the defendant can be seen driving past his colleague, who is also in a vehicle and who I suspect has similar training as the defendant. His colleague, who has stopped his vehicular pursuit and is beginning a foot chase. The defendant drives past the stopped vehicle and at least 2 other officers who are in pursuit, an estimated 20 to 25 feet away. The last element without justification is really the absence of an element. There was testimony that there was no weapon observed on the decedent during the pursuit, and no force was used by the decedent. No other officers continued in vehicle pursuit. Therefore, there does not appear to be justification for the defendant's conduct. Reasonable minds, of course, may differ. I think the matters of braking and speed, the impact on the circumstances of wet payment, and whether the defendant believed that the suspect might enter the Burger King and harm or threaten harm to patrons are areas where fact finders may diverge. But by a probable cause standard, I believe the elements of second-degree murder are met. There are more questions in my mind as to conflicting evidence in count 1 than in count 2, involuntary manslaughter. Many elements are the same, and I previously stated my findings. However, involuntary manslaughter contains the element of gross negligence. I believe by reason of his training and experience that the defendant was aware that the pursuit of a fleeing felon required at minimum the exercise of ordinary care and diligence, and that he had the ability to avert the harm. Defendant could have slowed or braked much earlier than he chose to, could have ceased his pursuit in the vehicle and proceeded on foot, or simply veered the other direction upon gaining proximity to the decedent. In failing to do so, there was impact between a human and a vehicle. And the ordinary mind can easily understand that a collision of that nature may prove disastrous. And so, in this matter, Defendant Keely is to be bound over to the circuit court